Hopefully it'll be just a minute. I appreciate your patience. Good morning. Could you please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the December 15th, 2025 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's agenda. Let me start by introducing Ms. Colleen Marshall. She's with the Development Services Department. She'll introduce other members that will participate in today's hearing and go over any off-the-agenda changes. Ms. Marshall.
Good morning, Colleen Marshall, Development Services. To my left is Cameron Clark of the Hillsborough County County Attorney's Office. To my right is Carmen Mason, the Development Services staff. Alexis Myers, the Planning Commission staff, will be presenting virtually. During the course of the hearing, a number of other staff planners will be presenting their findings for various cases and will be introduced for each item. There are no changes to the published agenda.
All right, thank you so much. I appreciate it. Let me start by going over our procedures for today's hearing. Our hearing today consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct a hearing on each agenda item and will file a decision within 15 business days following today's hearing. Our hearing today is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and I will decide all questions of procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it be admissible over objections in a civil action. Our order of presentation today is as follows. We'll start with the Development Services Department, who will provide for variances, will provide findings regarding their staff report for a period of 5 minutes. Next up will be the applicant. The applicant and everyone on their team, 15 minutes to make their presentation. Next, we'll turn to proponents, anyone who wants to speak in favor of an application. Everyone combined 15 minutes. Same is true next when we go to opponents, anyone who would like to speak against an application. Everyone together, 15 minutes. We'll circle back to the Development Services Department, who will have 5 minutes to make any changes or comments based on today's testimony. And then finally, the applicant has the last word with 5 minutes for rebuttal. Now, the majority of our cases are variances, and that is the order. The only difference in the presentation for the last several items, which are special uses, is the applicant goes first. So for variances, the staff goes first. For special uses, the applicant goes first. Otherwise, identical in presentation. I don't think this is an issue, but I'll go over it just in case. For those who want to speak in favor or against, when we get to that section of the hearing, I will ask you to raise your hand if you plan to speak. We have people both participating in the room and also online. So I'll take a show of hands, and we will divide that 15 minutes as equally as we can to make sure everyone has a fair shot. When you are up to speak, either in the room or online, start by giving me your name and address for the record. We are recording this hearing, and we want to make sure we have your information correct. If you're in the room and you're done speaking at the podium, if you could see Susan and Jermaine, raise your hands, guys. They're from the clerk's office. They are keeping a written log you'll see on top of the dais. And then so when you're done speaking, if you could check in with them and sign in with your name, address, and the case number to which you spoke, and that makes sure we've got everything correct. All right, with that, let me now turn to Mr. Clark. He's with the County Attorney's Office, and he will provide you the legal requirements for appealing a decision made by a land use hearing officer. Mr. Clark.
Thank you, Madam Hearing Officer. Good morning. My name is Cameron Clark, Assistant County Attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the appeals board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the appeals board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant, and second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It's the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside today's record could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments that you make today and to repeat those comments to the appeals board. Thank you.
Thank you so much. I appreciate it. As I mentioned, all testimony must be under oath. So if you plan to speak today, if you could please stand, raise your right hand, and I'll swear you in. Do you swear the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you so much. Please have a seat. Then with that, Ms. Marshall, we are ready to call the first case.
Today's agenda, we have no vested rights, fee waivers, remands, reconsideration requests, or site development variance requests, which brings us to Section G, sign variance requests. Item G1, variance 260102. The applicant is University Community Hospital Incorporated. The request is a variance to sign requirements. Staff findings will be presented by Sam Ball.
Good morning.
Morning, Sam Ball with Hillsborough County Development Services. The applicant is requesting a variance to reduce the front setback requirements to replace an existing monument sign at the entrance to an existing medical office. LDC Section 7030C1C requires that an 8-foot tall monument sign have at least a 19-foot front setback. The applicant is requesting a 19-foot minimum setback reduction to allow the 8-foot tall to have a 0 front setback. The property has 285 feet of frontage, which would limit the property to 1 ground sign, which means that the existing sign would have to be removed. Unless you have any questions, that concludes my report.
Not for staff. Thank you.
Thank you.
Appreciate it. Is the applicant here? Good morning.
Good morning. David Smith, 401 East Jackson Street, Suite 2200, 33601 for the applicant, Advent Health Carrollwood. This is just a restatement of what staff has just said. We're asking for a 19-foot setback for an 8-foot tall monument sign, which would provide us a 0-foot setback. The location of the sign is on this graphic is in a blue square on the left-hand side. It's immediately at the corner of the driveway entering into the medical office building site. Here's a site plan that depicts it as well. Arrow points to where the sign would be located and also confirms that we'd be removing the existing sign.
Mr. Smith, can I interrupt you? I hate to do that during the presentation.
No
Can you
problem.
go back to that site plan?
Yes,
Just don't
ma'am.
want to leave it. Where is the existing sign on this graphic?
It is pretty much at the same location, but about 16 foot, 19 feet further back where that arrow is. So the red line on the right-hand side is the curb line of the driveway, which is the property line. And so there's an existing monument sign that's much further back. And you'll see that in the graphic when further on.
Okay.
in the
One of my
presentation.
questions also was, what does that red line mean?
Yeah, that red line is the property line.
Okay.
Yeah, so there's different parcels. Staff asked that we put the folio boundary to give a reference because you have to meet side yard setbacks.
Right.
And we will meet that as well.
Okay. Thank you. Go ahead. Sorry.
Absolutely. So I'll get into graphics that indicate, or demonstrate what the issues are. But the width of the LMA right-of-way pushes the property line well back from the highway's edge of pavement, with signage having to be placed even further away from the travel lanes and driver view corridor. Compounding this are numerous streetlight, electric transmission and distribution poles all along the right-of-way line abutting the subject property, and the poles further obstruct patients' view of the office building signage. It should be noted that several of the utilities poles are large diameter metal type poles, adding to visibility obstruction. There's also a treed stormwater pond on the southern property line that obstructs the visibility of the medical office building. County landscape code compliance also requires buffering and screening of the parking areas, and as you'll see in the graphics coming up, effectively obscures the sign from being seen. That's the existing sign. And last but not least, there's an elevation change for the property. The property is higher than the travel lanes for Dale Mabry, and it also causes site visibility challenges. So this series of graphics coming up, the numbers represent where the photographs that will follow are located. Number one is about 633 feet away, coming down Dale Mabry Highway. And I think it should be pointed out that Dale Mabry Highway has a 45-mile-an-hour speed limit, so it's not a local road. It's people are traveling fairly quickly. 409 feet looking north, 299 feet looking north. You can see the medical office building now, but you still can't see the sign. At 128 feet on the right-hand side underneath the trees is the existing sign. It's a small red sign just by a light pole. Here, 89 feet, looking on the right-hand side, again, you can see it's obstructed by a street light pole for a parking lot and is far off Dale Mabry. Here at 54 feet, you can actually get a clear view of the sign. So imagine if you're a patient looking for a medical office building, and you're anxious about your doctor's appointment, and all of a sudden you're going to 45 miles an hour, and oh, there's the sign. They have to go all the way up, turn around, come back. It's not a good situation. And that is to make a safe turn. So these graphics just show, okay, if I'm standing on the sidewalk, and this sidewalk is right along the property line, if I'm standing on the sidewalk, I can't even see the sign that's in the medical office building. Here at 16 feet, I can see the sign, but you're looking over a hedge, and that's the first time you have a clear view. The variance requested, this is the site looking south. So where we're requesting the sign to be allowed to be placed, you can see that there's a more unobstructed view in this view corridor, and it would be right on the property line. Dale Mabry and the public sidewalk is further to the west. This is an exhibit of the sign. This is the placement of the sign where the variance would allow us to place it. Again, you can see here, it's much further west than the existing sign, but it gets us out beyond the landscape area. When you look at the landscaping code, when you're under power lines, you have to use trees that are low. When you get trees that are low, they end up full and they obstruct the signs. So based upon the evidence presented, we believe we meet the criteria of the code. The hospital's location and site constraints are unique to the property, and they create the hardship not suffered in common with similarly located properties. The unique nature of the hospital campus and patients requires consideration not required of other properties in the district and regulated by the sign code. Without the variance, the little application of the code deprives the hospital of rights enjoyed by others. The variance if granted will not negatively impact any adjacent property owners, as this sign is well away from any other signs in the area and will not impact them. The protection of the health, safety, and public general welfare, as stated in LDC 10202, is in harmony with this request of the public safety benefits of the hospital campus and sign location improvements requested. The situation where the variance seeks relief from is not a result of the legal act or actions of the applicant. In the handout that I gave you for the record, there's a report from Steve Henry. He's confirmed that this sign location meets all site visibility standards and also would provide for a safer turn to be made given the sign location, given the speed of Dale Mabry Highway. I have John Michaels, the last one. Variance requested provides enhanced public safety and health benefits consistent with the protection of public benefits promoted by the LDC, and will provide substantial justice and furtherance of the LDC when weighed against the hardships. I have John Michaels from Advent Health. He'll just give some testimony relative to why we're asking for this variance based upon the doctor's complaints.
Okay.
Thank you. Here to answer any questions.
I do have some questions, but I'll wait
Oh,
till you're
okay, great.
finished with the presentation. Good morning.
Good morning.
If you could give us your name and address, please.
John Michaels, the address of the facility.
Whichever address you'd like to
Okay.
give us.
It's 6919 North Dale Mabry Highway.
Okay, go ahead. Thank
Okay.
you.
Yeah, so it's a medical office building, as David has mentioned, and there's several suites within the facility, and a lot of the physicians that run the suites, they expressed to me that their patients have complained that they pass right by the building before they can turn in, and it's an inconvenience, and just asked if the sign could be, increased so that there'd be better visibility. So I've had emails come across my desk. I'm the facility director for the hospital, and we own the building, and I've heard from several of the tenants. We have some lease tenants, and we have some of our own people in the building, and they've all expressed, concerns about the signage.
All right.
So we're asking to have this completed.
Thank you so much. Don't forget to sign in.
All right, thanks.
Thank you. Okay, so a couple questions. One is you've already answered the location of the existing sign and what that red line means. So in reading your narrative, that the property boundary was not obvious to me, so I had a question about, you cite that the stormwater ponds that are on the south end and so forth, those are outside of the ownership of this property. Is that your testimony?
Yes, hold on here, and I'll get the graphic. So if you can put the graphic back, there you go. So, yes. So if you look on this graphic, kind of to the right of number 3, there's a little notch. That stormwater pond is all along that side of the property. That's owned by the hospital, but it is a different folio number. So we were only asked to put the folio number on there.
And so
it's-
is it the same property owner? It's just a different folio number?
Yes, but let me see if I can get the graphic up, whoops, to show you. This is the graphic that shows the mature trees. Those trees, Hillsborough County is not as bad as the city of Tampa, but they're pretty protective of their trees. And so those trees were required to be preserved during the construction there along that stormwater pond.
Okay. And you also cite the difference in elevation between the site and Dale Mabry. Do you have that specific information, the difference?
I do not have the measurement, but as you can see here on this graphic, the driveway here the travel lane is lower. As you go up, you can see that the driveway comes up to the uphill. Also, because of the elevation change, the medical office building was required to put that additional sidewalk in because the slope was too great to make a direct connection. So it gives you an idea that if you have to put in an ADA compliant sidewalk, that there's a significant grade change between the existing grade of the office complex and the public right-of-way.
Okay, and that picture you have up, does this building encompass the emergency room, or is that a separate
No, the
building?
emergency room is totally separate. As you can see in this graphic, further to the north, there's a lower sign that's red and white in the foreground.
Yes.
And you can see emergency, but on Dale Mabry itself, there's a sign as well. And we actually had to get a variance to move that sign up because similar obstructions. There's been some landscaping changes there since, but this is required landscaping under the code.
I see. All right, that's the end of my questions. Thank you so much.
Thank you much.
All right, we'll call for anyone that would like to speak in support, anyone in favor that would like to speak. Seeing no one, anyone in opposition to this request? All right, Development Services, Ms. Marshall, anything else?
Nothing further.
All right, Mr. Smith, you have the last word if you'd like it.
Nothing to.
All right, thank you. Then with that, we'll close variance 26-0102 and go to the next case.
This brings us to Section H, variance request. Item H1, variance 25-1452. The applicant is Alejandro Alique. The request is a variance to minimum lot size by available utilities. Staff findings will be presented by Orlando Boras.
Good morning.
Morning. This is Orlando Borras with Development Services. At this time, the applicant is seeking a variance from the Section 60106 from the Land Development Code, minimum lot sizes by utilities. In this case, the applicant is trying to split the property, creating a second one. Therefore, the variance will be resulting in Lot 1 being 0.27 acres and then Lot 2 being 0.28 acres. I don't know if you have any questions for me, but more than happy to.
Just a basic question, if you know, I know that requirement has been in the code for a very long time, but if you know what the purpose of the half-acre minimum was or is?
For the lot, it will be half an acre.
But the purpose of having it be a half acre as opposed to a quarter acre or something different, do you know why it was chosen to be a half acre of minimum upland?
I do know, and maybe Glenn may assist me on this one, but I do know it's supposed to be half an acre, and eventually, I believe it was in August, if I'm not wrong, there was a change and an amendment in the code which allows for this to be happen.
For the variance to be requested?
For the variance, yeah.
Understood. Ms. Marshall, do you have anything to add to that?
I believe it was originally for like drainage purposes, but the Department of Health ultimately determines if the septic is acceptable at the location.
Right. And to gentleman's point, the ability to request a variance to that is new, relatively. For this section of the code, that has actually been in place. However, Section 4, I believe it's 40203, in 2021, the exception to allow for the first two splits of a parent parcel to remain on septic was taken away. But then that was changed in August. I see.
So if you're in the urban service area now, they have the opportunity to remain on septic, but they are still subject to this requirement.
The minimum
But they could
upland.
seek a variance. Yeah.
Understood. All right. Thank you, sir. I appreciate it. Is the applicant here? Is the applicant here for variance 25-1452? It's item number H1 on our agenda. Any information? All right. We don't know, right? Okay, so what we'll do is we'll hold this application, and if we could try to contact the person, and we'll come back if we can. All right, then we'll call the next case.
Next item is item H2, variance 260038. The applicant is Todd Pressman. The request is a variance to accessory structure requirements and variance to lot development standards. Staff findings will be presented by Jaron Fallon.
Good morning.
Good morning, Jared Fallon with Development Services. This is a variance request for accessory structure standards to allow an existing accessory structure to occupy more than 20% of required rear yard and allow it to be closer than 3 feet from the property line. This application also is requesting a variance to lot development standards to allow an existing single-family home to encroach into the front yard and rear yard setback. So the accessory structure is existing, and they're asking for a 32.5% increase variance to allow or result in a 52.5% percent of required rear yard to be occupied. And they're asking for the setback to be a 2.1 foot rear yard setback. And then for the for the single family home, the side yard setback, they're asking for a variance of 3.5 feet, resulting in a 1.5 foot side yard setback. And for the front yard, is asking for 1.5 feet variance for an 18.5 foot front yard setback. And I'll also add there is an existing code compliance case on this for the unpermitted construction of the accessory structure. Happy to answer questions.
No questions at this time. Thank you so much. Is the applicant here? Good morning.
Good morning, hearing officer, staff. Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg. This is variance 26-0038. Located as indicated on the broad map. Looking closer, the single residential home is located on Pittsfield Avenue, just a little bit north of Timberland Street. And looking closer per the property appraiser, this is the site on Pittsfield. So there are a number of variances, which the staff just reviewed with you. I would say the first two are different than the second two. The first two have to do with the existing front yard, existing setback, and the side yard setback for the home. And then the other two variances, 3 and 4, are for the accessory structure. So I'm going to kind of break those up between the two because they're quite both different. So variances to the existing home, the home is indicated in the center one-story masonry, showing the front setback and the side setback. And one thing that's important is under the property appraiser in 1962, they show the unfinished carport, which I've highlighted there, which was a part of the home in 1962. And that's verified by the property appraiser's office, who noted that, as indicated here, the area coded UCP is what they define as an unfinished carport. So in 1962, that structure was there, has been there for a long period of time. This shows the site by aerial. And what I would say in regard to those two variances is that, which I'll get into more detail, that the really unique singular condition of this parcel is it is the smallest by far in the entire vicinity. So when you look at the parcel here, showed by 50 by 100, and just one at the corner is 100 by 100, but when you start going through all the square footages on this block, let alone across the street, Pittsfield, which you can see are tremendous much larger lots, it is by far the smallest lot, and is the smallest lot on the entire block. And even when you pull further away, as far as I can see, it was in the vicinity the smallest lot that would be possible, or that's existing. So when we look at variances for the accessory structure to the rear, we feel that's substantiated by the size or the small size of the property. So looking at condition number 1, hardships or practical difficulties are unique or singular subject property, we believe they are, because the property is by far the smallest in the vicinity, in most cases tremendously much smaller. In regard to the existing home, I've shown you that the side canopy was existing in 1962. The front setback is minimal at, I believe it's 1.8.
The staff report says 1.5.
1.5, which would be a condition of the formal home, which was done with permits. There is a permit on file for the enclosing of the front part of the home, where the latter two variances, as I indicated regarding the accessory structure, were cited for not having permits. So there's a big difference between those two. That 1.5 feet would affect the formal masonry structure of the home, and again was done by permit. But we would suggest that the element of the small nature of the property, being the smallest in the area, is a factor in regard to a minimal variance in that regard. The criteria number 2, little requirements of the Land Development Code to provide the rights commonly enjoyed. So we can certainly see throughout this block and across the street in the vicinity, others would have the ability under the code to have a larger accessory structure on their properties. And because of the singular unique nature of this property, they would not be able, they are deprived the right that others commonly can have. Criteria number 3, will not substantially interfere with the range of the rights of others. I did check the record late last week. There were no emails or letters in. I'm not sure who filed the citation, but as far as I can see as a day, unless someone comes forward, this would be an accessory structure that would be permitted in other properties. It does have a closer setback, but it would still, under item number 3, because accessory structures are permissible, and the rear setback is in the rear, it's 0.9 feet, is extremely minimal and would have no difference of effect on impact or encroachment at 0.9 feet. I don't think the human eye or anyone can stand there and recognize the difference of 0.9 variance for an accessory structure. Criteria number 4 is that the variance is in harmony with and serves the general intent and purpose of the LDC. We believe it does, because again, the hardship and unique nature, singular nature of this lot allows or should allow an accessory structure that others in the immediate area and vicinity can. Excuse me. Criteria number 5, sought to be relieved of variance and not result from a legal act. We're obviously here today to bring that variance in line. The first 2 variances, again, have received, or the first 2 items, the first item, the setback, received a permit. The side setback, as I've indicated, has been there for a long time since the home was built, and long nature. And item number 6, and I think this is important, that the variance will result in substantial justice being done, considering, again, size of the property, the small nature of the property, and the individual hardships that are being suffered to grant a variance. So with that, we appreciate your attention and happy to answer any questions you might have.
Just one quick one. You've covered most of it. So the primary structure of the house was in its current location and configuration when your client bought the property. Is that correct?
No, I have to clarify that. So the side setback, yes. The front part of the home was evidently enclosed, which again is a permit on record. I couldn't pull up the permit, but it's listed with the property appraiser. When I click for the permit, I assume it's pretty old anyway. It wouldn't come up, but yes, a permit was issued. So to clarify, the side was when the home was built, the front was done sometime after under permit.
All right, thank you. That was my only question. I appreciate it.
Thank you.
Right. Go for anyone to speak in support. Anyone in favor? No one, anyone in opposition to this request? No one. Ms. Marshall, anything else?
Nothing further.
Press of the board, you'd like it? No, thank you. All right, thank you. Then with that, we'll close variance 26-0038 and go to the next case.
Next item is item H3, variance 26-0086. The applicant is Barrington Watson. The request is a variance to community residential home separation requirements. Staff findings will be presented by Michelle Montalbano.
Good morning.
Good morning, Michelle Montalbano, Development Services. The applicant is requesting a variance to the community residential home separation standards to accommodate a proposed Type A C or H facility. LDC Section 611-28A states community residential homes housing 6 or fewer residents shall not be located within a radius of 1,000 feet of another such home with 6 or fewer residents. In this case, the Florida Agency for Healthcare Administration records show an active Type A community residential home at 4534 Hampshire Road in Tampa. The variance for 815 feet, resulting in a single-family residential area.
Does that have any to is in here? Go ahead and come forward, sir. Good morning. If you give us your name and address to start.
My name is Barrington Watson, 4519 Devonshire Road, Tampa, Florida, 32634.
Okay. If you could tell me a little bit about your request.
My request today to open a facility is because there's not much small facility in the neighborhood, so I want to open my own facility because I've been doing these jobs over 15 years, and I decided I want to go on my own and open my own facility.
And I read the backup to the request. It said when you did the research for this particular site, there wasn't another facility in the distance. Is that correct?
Yes, ma'am.
All right. And what type of, what is your clientele? Are they elderly or? Elderly people.
Yes,
All right.
ma'am.
All right. I didn't have any other questions. If that completes your presentation, that's all I have.
Thank you, ma'am.
Thank you, sir. I appreciate it. If you could please sign in. Is there anyone who in the audience or online that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition? No, Ms. Marshall? Anything else?
Nothing further.
All right, sir, you have the last word if you'd like it. Anything else to add? Oh, you got to go to the microphone, sorry. Thank you.
I would say I would like to grant this variance to open this facility.
All right, thank you so much for your testimony. I
Yes,
appreciate it. All right, then with that, we'll close variance 26-0086. Do we have any information on the applicant, the prior case?
Yes, he's on virtually now.
Okay, so let's, before we get too far ahead, let's go back and pick up that case, item H1. And so we're going to open variance 25-1452. My recollection is we did the staff presentation and we were ready for the applicant. So if the applicant is online, if you could give us your name and address, please.
Hey, my name is Alejandro Yeager. My address is Chris Road.
Sir, let me, the county requires that you turn your camera on so that we have a visual in addition to your voice. Can you do that for me?
Yes, ma'am.
There you go. All right. Name and address and
Yeah, my name is Alejandro Yeager, and address is 1110 Lithia Pinecrest Road in Brandon, Florida.
Okay. And tell me about the variance request, please.
So we're submitting a variance because we're just now getting into like construction, and so we're kind of learning with the process. The first time submitting a variance, but I feel like, I've looked up a lot onto it, and I feel pretty informed of how the process is going. But we have a property that we purchased, and we demoed the existing home there. Size, it's about 0.67 acres, and we wanted to divide the lot into two in order to, construct two single-story homes. And the only issue we're having is that we need at least 0.5, and
there that are of
home where the septic system is in the front of the house and the well is all the way towards the back corner. We're looking to do something similar with ours while also maintaining distance because we know there's regulations between, the distance between our septic and their wells, and, and et cetera.
All right. Well, those are my only questions. If you don't have anything else to add, we'll move on if that's okay with you.
Okay. That's it.
Thank you, sir. I appreciate it. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? All right. Ms. Marshall, anything else to add?
Nothing further.
All right. But you don't have to take it.
Okay. That's all I have to say.
Okay. Thank you very much for hopping online with us. I appreciate it. Then with that, we'll close variance 25-1452 and go back to our agenda.
Awesome. Okay, I'm going to...
The applicant is Todd Pressman. The request is to community residential home operation requirements. Staff findings will be presented by Tanya Chappella. I can present.
Okay. She was here, I saw her.
The applicant is requesting a variance to the distance separation requirement for a type A community residential home to allow a type A community residential home within 1,000 feet of an existing facility that's located on North Boulevard. The requested variance is 700 feet for a resulting separation of 300-foot distance separation to the existing community residential home. And the existing home, North Boulevard Group Home, is a community residential home for up to 6 residents that's located at 13121 North Boulevard. Available if you have any questions.
Just a couple. There are letters and a petition in opposition in the backup for this file. And several of them talk about that this is the second time this request has been made on this property. And can you give me a little background about that?
Sure. There was a rezoning rezoning proposed for planned development for a type B community residential home, which has more residents, that was denied. And so this request is for a type A community residential home, which would be limited to 6. And this is just for the distance separation.
So not the same application, just related in that it's the same use, but not the same
Correct.
application type or?
Correct. And it's the same use, but the different, there's 3 different types based on the number of residents. So the original request was a type B, and now they're going down to a type A.
And certainly a
proposal.
different process because this is the variance rather than a rezoning.
Yes.
Understood. All right, thank you so much. Is the applicant here? Good morning.
Good morning, Hearing Officer Todd Pressman, 200 2nd Avenue South, number 451, St. Petersburg. So yes, as you've heard, I'm here with LaTanya. There she is. LaTanya Boyd with 1,000 feet of another 6-bed. Community residential home, 6 or fewer residents shall be deemed a single-family unit and non-commercial residential uses for the purpose of this land development code, and residential appearance of the structure is required. This is in the greater Carrollwood area, Northdale area, 0.73 acres, located on North Boulevard at the corner of 131st. It's south of Fletcher Avenue, as you can see here, and per the property appraiser at the corner of North Boulevard and West 131st Avenue, currently vacant. Item to consider, located with 1,000 feet of another community residential home, which, as staff indicated, is located approximately 300 feet north. The home, which, as staff indicated, is located approximately 300 feet north. It's a small 6 female support home that appears completely residential from the exterior, as that site is very small, blends in well with the residential area, and provides a support use. So this is the other use, as I'm showing by an aerial orientation between the site proposed and the 6-bed, which is existing to the north, and that's a photo of the site, which again is very residential in nature. So when you look between these uses, you can see that there's 2 or 3 residential homes and separation between them. And as you travel up the roadway, as you can see, a lot of the forestation. This is the proposed site on North Boulevard, 131st. This is the home abutting on the east. You can see there's to promote residential infill, flexible building envelopes, parking, access, setbacks. Development of community residential homes will be allowed within each of the land use categories that permit residential development, and 1.6.15 to promote and prioritize senior housing and opportunities to age in place, which is exactly what this use does. That's what the comp plan desires and directs. And again, as
feeling in the neighborhood. So I said, okay, and one of the persons that spoke, which was a neighbor who lived next door, and she said, I would welcome a 6-bed. I bring over cookies. I just don't want it to look commercial. And I heard them, and I agree with that. And I said, you know what, sometimes I don't get everything I want.
And just start by giving us your name and address, please. Good morning. To testify in opposition, we'll go back to Development Services. First, Ms. Marshall, the assertion that this is a commercial use, is it accurate to say that a community residential home type A is considered a residential support use and not a commercial use?
Correct.
All right. And we can ask, perhaps if it's not your expertise, but the question about used for other purposes other than the care of elderly people. This is a licensed facility, correct?
Correct. So,
Go ahead.
as a community residential home, they would be licensed through either the Agency for Healthcare Administration, the Agency for Persons with Disabilities, or the Department of Children and Families. So it could potentially be a group home if, in some instances, under that definition of community residential home that could have, not necessarily elderly, but other people that need assistance.
But is it accurate that when this facility applies for that appropriate licensing, that they have to identify who they are caring for? What type? If it's elderly, is it children? Is it? They have to identify that. Is that correct? And we can ask Ms. Boykins on a rebuttal.
Yes, when they submit for their zoning verification for their zoning sign-off for their licensing, it's through the specific agency that they're licensing for.
All right. And then if they, in the future, were to change that, what is the process to amend that licensing?
It would be a new zoning verification that they would come in.
So they would have
for.
to go back through the process. Is that accurate?
Correct.
Okay. All right. Thank you. Then we'll go now to back to the applicant. Mr. Pressman?
Thank you, Your Honor. So may I ask to use the aerial that the young lady presented? So on the overhead, I just wanted to draw some clarifications with respect to the young lady. This is Fletcher Avenue. The site is here. I'm not sure why this to the north is designated. It's not part of the property, as I showed you the precise location of the parcel. So I just wanted to clarify for you. I'm sorry. Let me make sure I have my orientation correct. So this is North Boulevard. This is Fletcher. The site is located at the corner. To my view, this area here is extended more than it should be. It should be just a corner property, as I've shown you from the property appraiser in my PowerPoint. The other not clarification, but to bring your attention, this site here is one of those large facilities. Its orientation is only to Fletcher Avenue. There's no, or it's a commercial use that is primarily off of Fletcher Avenue. So that is a site that, as we get the reports, is not within the 1,000 feet. But I just wanted to clarify for you, I don't know about the other sites, or the other sites. I assume the one more research, I assume is correct. But I did want to at least clarify those 2 points for you in the aerial. Thank you.
All right.
Oh, and then I'm sorry. So just to reemphasize, from the last request, this is 50% less. It brings it down from a Class B to a Class A. When LaTanya and I spoke after the hearing, and as you heard, she spoke with neighbors, we wanted to bring back something that we felt would be a lot more acceptable to the community. We did have a pretty large crowd at the first hearing, and I'm glad to see that that's been dissipated quite a bit. So with that, we appreciate your attention. Thank you.
Mr. Pressman, before you leave, and maybe your client can participate in this, the assertion that this could, if today's use is for the care of elderly, what is that procedure if you wanted to come back and change to another type of care? For instance, people say drug rehab or something like that. If you could address that issue.
LaTanya is better to answer that.
Perfect.
Yes, as a court trainer for the state of Florida, it just doesn't happen that way. They would have to apply, and they would have to be approved. If we open this up just for seniors through the Agency for Healthcare Administration, that's all that this use would be able to be used for. I couldn't tomorrow go, I want to open up a drug treatment center, or I want to do something else.
So I want to clarify, this is not, as you recognize, I just want to state from what Latanya just said, this is not a professional rehabilitation center. This is a community residential home.
And your intent is to care for elderly
Yes,
citizens?
Yes, my population's between 75 and 104 currently.
All right, thank you. I think that answers the question. Mr. Pressman, does that complete your testimony?
Yes, thank you.
All right, thank you. Then with that, we'll close variance 26-0094 and go to the next case.
Next item is item H5, variance 260109. The applicant is Fakir Hussain. The request is a variance to let development standards. Staff findings will be presented by Sierra James.
Good morning.
Good morning, Sierra James with Development Services. The applicant is seeking a variance to the rear and side yard setbacks in LDC Section 60101 to accommodate their proposed home expansion. In the RSC 6 zoning district, the required rear yard is 25 feet and the required side yard is 7.5 feet. The applicant is requesting a variance of 22 feet and 1 inch, resulting in a 2-foot, 11-inch rear yard setback, and a variance of 5 inches, resulting in a 7-foot, 1-inch side yard setback.
Thank you so much. I appreciate it. Is the applicant here? Good morning.
Good morning. Mr. Hussain couldn't make it for medical reason, so I'm the homeowner.
Okay. If you give us your name and address, please.
Sagar Saha, 1004 Eccles Drive, Tampa, Florida, 33612.
Thank you so much. Just tell us a little bit about your request.
So I'm here for today to request a 2 feet 11 inch of variance. We'd like to add a small office room in the back of the existing house and a small lanai for recreation. Please note that the backside of my properties are very unusually shaped. The space between the between the lake and the structure, there's a lot of unused square footage, buffer land. Some places are more than 50 feet going towards the lake. I've been maintaining this space and with lawn care and everything for the last 13 years. And I'm sure the small expansion will not hinder to my neighbors in any way. I do not have any neighbors in the backyard. It just opens up to the lake. My family is experiencing a hardship lately. We need some extra square footage for living space. My parents, my elderly parents, are moving in with me, and I'm the primary caregiver. We are planning to hire a overnight nurse aide and for my parents, and she will need some kind of accommodation to stay the night. And also, my wife works full-time as a healthcare professional, and she requires a separate room with key and lock per HIPAA requirements. And my son is growing up, so he needs a room too. He sleeps with us currently, but we have rooms, but we need an extra room would help. So, yeah, and my GC is not here, so I'm not very technical. There is the lanai, which is actually there's a invisible line there, which is, I guess this is the property line. I'm not sure which one is the property line because there's a lot of land behind the line and there's seawall here. There's a 2 feet 11 inches, that's a 45-degree angle. There's a little window of the lanai is close to that line. So requesting.
Right. Yeah. So the home is there, and this is just for an expansion?
Yes, ma'am.
I understand. All right.
To the existing home. Because I have to change the roof anyway, so I thought it'll be the good time to do it.
Understood. All right, I understand your request. Thank you so much for coming down. If you could please sign in with the clerk's office.
Thank you.
Thank you. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? Ms. Marshall, anything else?
Nothing further.
All right, sir, you have the last word if you'd like it, but you don't have to take it. Okay, thank you. Then we'll close variance 26-0109 and go to the next case.
Next Next item is item H6, variance 260110. The applicant is Awaken Assisted Living, LLC. The request is a variance to community residential home separation requirements. Staff findings will be provided by Jared Fullen.
Thank you.
Hello, Jared Fallon with Development Services. So this is a request for a variance to the distance separation requirements for a Type A community residential home to allow a Type A community residential home within 1,000 feet of an existing facility. So this proposed home is going to be within 650 feet of an existing home. So it's a variance of 350 feet. Happy to answer any questions.
No questions. Thank you so much. Is the applicant here? Good morning.
Good morning. Richard Coson, 330 Pauls Drive, Brandon, Florida, 33511, on behalf of the applicant. The applicant is Awaken Assisted Living, LLC. It is operated by Shamara Bryce and Otavia Edwards. They're both registered nurses, and they currently operate a second community residential home, and they would like to operate a community residential home at the location of the residence at 12335 Yellow Rose Circle in Riverview, Florida. That zip code is 33569. The property is zone PD. It's an existing neighborhood. Future land use is R4, and it's approximately 0.38 acres. And it's an existing home. It's a 5-bedroom, 4-bathroom home, and it's perfect for the type of facility they would like to utilize. It's going to be for care of up to 6 elderly residents. The existing home that's about 650 feet away as the crow flies is also a community residential home A for up to 6 residents. The unique thing about this proposed project is that it's only 650 feet away as the crow flies, but it's approximately 0.6 of a mile, over 3,000 feet away if you walk or drive it. They're also in distinct, separate parts of the neighborhood, so they come in off of different driveways off of Boyette Springs Road to access the neighborhood. We request this operation, or this variance, for the separation requirements for the existing facility that's operating at 12210 Netherfield Court in Riverview. If I could show you here. You can see that.
If you just bring that microphone with you. It
Oh,
moves.
okay.
Yeah.
Yes, thank you. The existing home is shown here. The proposed home is here, and that distance separation is 650 feet. But you can see from the Google Maps, the dark blue is how to access it from one direction. The light blue is accessing it from the other direction, and you can see that the entrances off of Boyette Road are for 2 different entrances to access the 2 different facilities. So although they are 650 feet apart, effectively they're over 3,000 feet apart because there's no way to walk or drive directly from one to the other.
Does your client have any affiliation with the home that's within that distance?
They do not, Your Honor, and they are here and they can answer that question directly if you would like.
All right, thank you.
We recognize that the distance requirement that's set forth in LDC 61128 is designed to prevent the concentration of community resident homes in any particular area. We think that the way this neighborhood is existing, the separation by an effective distance of over 3,000 feet, either walking or driving distance, the separation of accesses off of Boyette Road, effectively, these are more than 1,000 feet apart, and they will absolutely be able to effectuate the goal of there not being a concentration of residential homes in an area. Addressing the variance criteria response, the alleged hardships or practical difficulties are unique and singular to this particular piece of property because of the separation by 3,000 feet of roadway when traveling by car or by foot. The literal requirements of the Land Development Code obviously would prevent this facility from operating because it is within 650 feet as the crow flies. And as I've stated, it's not, it's effectively 3,000 feet away. If allowed, the variance will not substantially interfere with or injure the rights of others whose property would be affected by allowance of the variance, because it's more than 3,000 feet away effective distance. The application fosters and preserves the public health, safety, comfort, and welfare, and aids in the harmonious, orderly, and progressive development of the area by permitting development that's consistent with the Land Development Code and the comprehensive plan. And the proposal does not negatively affect natural resources or public facilities, and it equitably permits development of the property or use of the property as it is currently located. The operation is in keeping with the nature of the surrounding homes, because it will effectively not result in a concentration of community residential homes because of the separation by, of the effective separation by 3,000 foot. And I think critically in this case, substantial justice will be done in granting the variance because it will not result in the concentration of the homes, and it will allow the service of residents in this in the community. We provided notice as required. I received one call. I attempted to call the individual twice. I don't know if it was an opposition or support or if they're just asking questions. This is my attempt to make contact with that person was not successful. Received no other calls in opposition or in support. I have for you, may I approach?
Yes, if you'd like to submit documents, you can give them to the clerk, and that will be a part of the record.
What this is a presentation by the applicants of their operations. And you can see when you review it in the executive summary, they currently operate a 5-bed licensed assisted living facility at 11102 Purple Martin Boulevard in Riverview. They successfully serve residents there for they have 0 violations, 0 complaints, full occupancy, safety compliance, and second 1335 Yellow Rose Circle in order to operate the same type of facility, and they were going to operate it with the same level of care. As I indicated, Ms. Bryce and Ms. Edwards are both registered nurses. They are committed to a strong resident advocacy, honest, supportive communication with families, strict compliance with AHCA standards, safe, accountable, compassionate environment, and being a positive and respectful part of the neighborhood. As part of that, they're planning to make no changes to the existing residential nature of the property. They're not going to make any outside changes. The only changes that they would make would be to the inside of the property for safety considerations, installation of grab bars, interior ramps for accessibility if needed, increased lighting, fire alarm and smoke detector upgrades, secure locks, and non-structural accessibility changes. So there's not going to be any external changes. It will maintain its residential nature, and any changes inside will be for the benefit of the residents. The staffing structure is that Shamara Bryce, the RN, is going to be the administrator. Otavia Edwards, an RN, is going to be the director of nursing, and they will have trained and licensed caregivers available 24/7. As they have operated their other facility, there will be no disturbance to neighbors. They have extremely low traffic, peaceful residential presence. They will maintain a clean and well-maintained property, and they will have HOA approval within the community. I think importantly, they're going to maintain the same level of care and compliance with this facility that they have with the other, which they have had no problem with. And if you have any questions, please feel free. I don't know if Ms. Edwards and Ms. Bryce would like to weigh in as well, and they were sworn in earlier.
All right, thank you so much. Good morning. If you could give us your name and address.
My name is Edward. I just wanted to say the our residents about what we do, and we make sure that I make clear is that what is there are and box and they're able to walk around creating for the
term association with right there. And add anything. What's your name and address first?
Tomorrow, guys. Good morning, guys. Thank you for having me. Address is 1 West Fortune Street, Tampa, Florida.
Thank you.
Really space where we could like help the seniors. So like this is a opportunity for us to like provide that service. Just be there for the families and the residents as well. It will mean a lot for residents that are like waiting like family or like appreciate you.
Sir, to complete your presentation.
I just want to point out, in other words, to paved roads, there'd be no question regarding the setback requirements set forth by the land code development. But being that Fifth Street is running on the front as well as parallel on the side of the property line, which I've got a survey of property here. So, currently, yes, this street runs in front of the house. I didn't extend farther plans to pave and the back is a female lens area, so paving it would be astronomical to clear that lot there. 50 feet, if that what we are asking for today is get that property line. That way we can place a spot where it accommodates Mr.
Let me ask you, you said land area? Can you show
It is going to be one. I should have printed out a bigger one, but I had to shrink it. So this is triangle part.
are not.
But going to be wetlands area.
Is there a associated with
Not that access plus from.
All right, and then tell me, it's quite substantial. What are they doing?
Just storage also is to people's inside. Yeah.
4480. To up the property and the appearance. The septic. Yes, all would the septic area in.
All right, you can see the point of my. I see where the are, but if you just turn the orientation, it's a very large structure and. The setbacks from zoning, and is there so to what location?
You know, Mr. Mayor did have a building that he out on, but with a lot is situated with using actually due to the grade and the allocation is the.
Thank you. Appreciate it. 26-012.
Applicant is Hillsborough County Water Resources Department. The request special use for a water treatment facility and variance to landscape and buffer requirement. This will be
All right. Florida. 5 years of camp project. Just going to quickly mention there are 3 areas associated with this project. The first is the eastern segment of that project, overall project, wastewater treatment facility. The type 3 facility, which means I'll go into a little bit more of the detail. The project is what that response to. This is a project that's intended to serve the needs of the community through 2050. It's a long-term project. The applicant in this case is actually Hillsborough County Water Resource Department. This case is actually Hillsborough County Water Resource Department. And based on the county property appraiser's website, the address is at 15960 Highway 672, that's Baum Picnic Road. I mentioned that because I believe in the staff report there's a typo to the address, so I wanted to bring that to the attention. Thank you. The site is a little bit over 200 acres in. Oh, this one jumped a little bit. And as I mentioned, the type 3 facility capacity that's slated for 30 million. Jumped a little bit. And as I mentioned, the type 3 facility gallons per day, but also is master planning. Planning to be able to serve a future build out. Of 45 million gallons per day. The future land use is an agricultural rural, and then this is the map from the county. And then the zoning, the existing zoning is agricultural rural. It is surrounded on the north, east, and west, all by parts of the overall project, and stormwater facilities. Rental approvals. So I just bring this to attention because the county has been where staff has been. That was my only question. Thank you so much. Don't forget to sign in.
Yep.
Good morning.
Good morning, Tim Lampkin, Development Services. This special use is for a wastewater treatment facility. The applicant went over. The request includes variances with the applicant's justification for the variances. Properties to the east, west, and north sides are bounded by Hillsborough County properties. To the south, there are small farms and agricultural uses. Staff notes that the applicant proposes predominantly a stormwater ponds along a portion of the southern periphery of the property between the facility and County Road 672, providing a geographical buffer and visual buffer between the proposed use and the agricultural and residential use to the immediate south. Before I forget, the revised report, there was a 0 instead of a 9 in the address, and so that was the report that was passed out.
I did see that. Thank you.
And per LDC section 6.11.102, the applicant's requesting waivers to the minimum 500-foot distance requirement, which requires that type 3 plants have a distance of 500 feet from the plant to the project boundary. It further requires that there shall be no plotted lots or dwelling units within this requirement. The applicant is requesting, these are the waivers. So the waivers are to the north, the east, south. On the south side, the project is bordered by this County Road 672, which is an approximately 60-foot wide county arterial roadway, and it separates the proposed facility from the properties to the south. And as previously stated, the design of the project places large pond area and an administrative building in closest proximity to the properties to the south, and places the main functional elements of the wastewater treatment plant on the northern portion of the site. Staff has no objection to the waivers. And to the variances, because County Road 672 is a designated rural scenic roadway and it needs to comply with the tree planting requirements. And so the applicant is proposing not to keep it in its natural state. Basically, it's already not in its natural state. So normally the requirement is a 30-foot scenic area. And because it's already predominantly sodded, I don't believe the applicant went into that detail, but it is in their application and their variance request. The applicant's also requesting variance of LDC section 6.06.03.b, and this is what the applicant went over, the 6 trees per acre, which the applicant's proposing to provide 1 tree, but just along the perimeter. That's not 1 acre for the entire site. And then they're also proposing a variance for land development section 6.06.04.d, which is the vehicular use area buffer, which would normally be 6 feet in width, and the applicant is proposing not to provide the VUA buffer and to reduce it to 0. Staff finds the overall request supportable and recommends approval subject to the conditions of approval. And that concludes my presentation, unless you have any questions.
No questions at this time. Thank you so much. To the Planning Commission.
Yes. Good morning, Alexis Morris, Planning Commission staff. In the it is a rural area and the limits of community white system. Proposed advanced water facility is the intent of the rural area to provide central public infrastructure that will support surrounding areas. While the facility represents a more intensive use than typical agricultural parcels, the site consists of a large single parcel that can be proposed with the site design measures to maintain the rural character of the area. Proposed uses are compatible with the existing uses in the area, and there are adequate mitigation measures such as buffering, screening, noise control measures, and odor control measures in place to minimize potential impacts of the adjacent residential properties. Based upon those considerations, Planning Commission staff find the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the proposed conditions by the Development Services Department.
Thank you, Ms. Myers. I appreciate it. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to the request? All right, Ms. Marshall, anything else?
Nothing further.
Ma'am, you have the last word for rebuttal if you'd like it.
Nothing further.
All right, thank you very much. Then with that, we'll close special use GEN 25-1135 and go to the next case.
Next item is item I2, special use 260031. The applicant is Ricardo McKinney. The request is a special use 2 COP alcoholic beverage permit with separation waivers. Logan McCaig will provide staff findings after presentation by the applicant.
All right, is the applicant here? Good morning. You can give us your name and address, please.
Ricardo Maghini, 10277 Big Bend Road, Riverview.
Thank you so much. And just tell me a little bit about your request.
Request for my Italian restaurant in Riverview. It's a small business, arrived from Italy. And I think the request for beer and wine to COP, because there is experience for my Italian restaurant. It's a good mix for the food and wine, and I need for the experience for my customer, because it is important for the business. Have the wine and beer. Don't have a bar. It's a small business. It's only 30 customers, and it's open to lunch to dinner, and it's for the family atmosphere. And that's it.
All right, thank you so much. I appreciate it. If you could please sign in. All right, Development Services.
Good morning, Logan McCaig, Development Services. The applicant is requesting a 2-COP alcoholic beverage permit with distance separations waivers at 10277 Big Bend Road for use with an existing Italian restaurant. Per LDC Section 61111E3 provides for approval of separation waivers where there are, quote, special or unique circumstances where the alcoholic beverage use applied for does not have significant impact on surrounding land uses, and certain circumstances negate the necessity for special distance requirements. The proposed whetstone area is within a commercial shopping center separated from residential and institutional uses and surrounded primarily by other commercial locations. The proposed whetstone area is already under operation as a restaurant. The addition of alcoholic sales to the location does not introduce, a new use to the site, but a natural extension of the existing and permitted function. The subject property is located along Big Bend Road, a major arterial roadway where commercial uses are expected to be located. Of the other alcoholic beverages within the 1,000 feet of the property, one of them is no longer in use currently. The other existing similar location beverage permit classifications within 1,000 feet are developed as 2 restaurants and a bowling alley. The existing restaurant and proposed whetstone area in the entrance faces north towards Big Bend Road, away from the multifamily residential development further south and of the subject property, and a large retention pond and vegetation separate the proposed whetstone area from the multifamily residential zone development. Similar commercial uses are located to the northeast and west of the proposed whetstone area. Staff finds 2-COP alcoholic beverage permit to be approvable based on the submitted whetstoning totaling 1,432 square feet, as shown in the whetstone survey submitted received November 25th, 2025. Available for any questions.
No questions at this time. Thank you so much. Is there anyone in the audience or online that would like to speak in support? No one. Ms. Marshall, anything else?
Nothing further.
Sir, you have the last word if you'd like it. Thank you for your time. I appreciate it and coming down. We'll close special use AB 26-00 case.
Last item is item I3, special use 260112. The applicant is 1051 Falkenberg, LLC. The request is a special use 4-COP alcoholic beverage permit with separation waivers. Tanya Chappella will presentation by the applicant.
All right. Good morning.
Good morning. Clayton Bricklemeyer with Hillward Henderson, representing the applicant. Very, very quick explanation. This is for a 4-COP. This is an existing 2-COP. The distance waiver is from this residential neighborhood. This entire boundary has a wall, and the entrance to the hotel is here on the east side. We calculated 1,000 feet from door to door to the closest residence. I think Ms. Chappella put in her report 700 feet from some similar distance. Either way, that would be in excess. No issues that anyone's reported on the existing 2-COP, so we appreciate the recommendation of staff and are okay, obviously, with the condition rescinding the 2-COP and available for questions.
Just quick, did you hear from any of those residents when you applied?
No, ma'am. No
and
word.
I assume that you had to get this same waiver for the 2-COP?
We did. I didn't, but yes, they did.
Someone did?
Yes.
All right. Thank you so much. Don't forget to sign in. Development Services. Good morning.
Good morning. Tanya Chappella. I need to present revised reports. The wet zone survey has to be changed.
Thank you so much. Appreciate it.
The applicant requests approval of a 4 COP permit to allow the sale of beer, wine, and liquor for on-premises and off-premises consumption, including package sales within an existing hotel. The proposed premises do not meet the 250-foot separation from residentially zoned property. The nearest residential property is located approximately 49 feet to the west, resulting in a requested waiver of 201 feet. However, staff finds that substantial physical and visual separation exists between the proposed use and the residentially property. The sites are separated by mature trees, parking areas, and a concrete wall with no direct access between the two. The proposed wet zone is located over 700 feet from the nearest shared roadway and residential access point. Hotel access is oriented to Palm River Road and South Falkenburg Road, while residential access is oriented to Balaye Run Drive, eliminating direct line of sight or functional interaction. Based on these conditions and the wet zone survey dated December 3rd, 2025, reflecting a total wet zone area of 15,686.79 square feet, staff finds the request approvable, subject to conditions. Approval includes rescission of the existing 2 COP permit, special use 14-0826, and staff recommends approval.
Let me just ask you, Ms. Chappelle, real quick. You submitted a revised staff report, and it's due to the wet zone survey? Is that correct? What's the change?
Yes, the survey required to include the 49 feet. There's a arrow that needed to be included, and when the applicant did that, the whole survey was not included. So the survey consists of 3 pages, and the applicant just included 1 page. So technically, it's the same information, but we needed to do that